very honored to be able to move to our first keynote address of this conference, and we have with us Richard Ryder today. It's a real pleasure and honor to have him with us. Richard was an undergraduate student at Pembroke College here in Cambridge from 1960 to 1963, where he read experimental psychology at the time. He's also got a PhD from Cambridge in political and social sciences. As many of you will know, he worked for years in Oxford as a clinical psychologist and later as a political lobbyist at Westminster for IFAW. For 50 years, he was an elected trustee of the RSPCA, several times RSPCA chairman, and currently the first president of the RSPCA. Richard's published 10 books. He coined the terms speciesism and Painism. He founded the Eurogroup for animals in Brussels, secured huge RSPCA funding for the rapid development of animal welfare science, and for purchasing the first Sea Shepherd boat as well. Richard's lectured internationally, reformed and modernized the RSPCA. He was a president of the Liberal Democrat Animal Welfare Group. He ran for president and was a Mellon Professor in the Department of Philosophy at Tulane University. He's also seen the passage of some 56 new European pieces of legislation to protect animals. And he was also awarded the Richard Martin Award in 2003 and the Peter Singer Prize last year. In his address today, he will talk to us about Painism, speciesism, and the law. And I look very much forward to the address. Thank you very much, and the floor is yours, Richard.
Well, thank you very much, Raphael. Ladies and gentlemen, this is probably one of the most unwise things I've ever done, putting my name to a paper with the word law in its title. And I'm not a lawyer at all, and never will be. I'm a psychologist, a campaigner, a bit of a philosopher, and a neologismist, but not a lawyer. So please forgive me, and thank you for inviting me to speak here today. I'll be addressing how the law can reduce the sufferings of animals. I have this very simplistic view that the law should be built upon morality, and that moral rights more or less form the foundation for legal rights. I also believe that moral rights belong to all creatures who can suffer pain of any sort. Non-human animals, human animals, and perhaps some computers, aliens, and robots of the future. I believe that anything capable of suffering is a person in the sense that he or she has rights. Moral rights are built upon the capacity to suffer. So we could say all painients have rights, where the words pain and painient cover all negative feelings, not just so-called physical pains, of course, but all emotional, cognitive and other negative feelings also. I was tremendously impressed by this morning's papers, but surprised that the word pain and the word consciousness hardly appeared. Let's say that all conscious beings deserve moral and legal rights. Then we cover all eventualities. I'm afraid I have about 10 points to make, and this is far too many, so I'd better get a move on. The title of my paper may be mysterious to some people in the audience: Speciesism, Painism, and the Law. The first two words are ones that I coined in 1970 and 1990 respectively to launch my campaigns to put animals into politics. Speciesism is defined as a human prejudice that holds that all other species are considered to be inferior and may therefore be used for human benefit without regard to the suffering inflicted on them. That at least is Collins's definition. I drew the analogy with racism and sexism. Sexism, racism, and speciesism are all similar prejudices. In the 1970s, I was invited to appear on radio and television shows in Europe, Australia, America, Canada, Russia, and the Ukraine, and so had the opportunity to spread the word speciesism, and the word is now quite well established. I had the luck also to interest the young Peter Singer, who liked the term speciesism and further spread it in his excellent book Animal Liberation. Incidentally, that campaign of the 1970s revived the whole issue of ethics, which had in previous decades become slightly neglected. The informal Oxford group of young philosophers was formed, and it was the animal issue that drove us. The modern animal rights movement started in Britain, by the way, not in America, despite Wikipedia. It was started by young Britons objecting to blood sports in the 1960s. By the time Peter Singer arrived in the UK, all sorts of protests against blood sports and cruel experiments were already well underway. Peter very wisely took it all to America a little later, yet American writers still sometimes get the history in the wrong order. Not that it matters. New laws. In 2022, I believe we're living at the dawn of a new age when many young people are discussing the human-animal relationship. There's a huge tidal wave of feeling that all of us animals are brothers and sisters. We can all suffer. We are all in the same boat of suffering. We all have this problem of pain that we have to avoid or overcome constantly, moment by moment. Countries all over the world are suddenly becoming interested. New laws are being passed out of the blue. Look at the case of Ecuador, for example, where the death of one poor little woolly monkey in 2020 has led to their constitutional courts to pronouncing upon the rights of animals as a separate entity from the rights of nature and the rights of humans. Animals are seen as legal persons and rights holders. They seem to have habeas corpus. But scientists, philosophers and lawyers speak different languages. Will they be able to talk to each other about the same things, rights, moral status and pain? Dr. Stephen Wise has summarized the situation in the USA, where the courts seem to be obsessed with the idea that animals are not persons. No court seems to dare to state the obvious or to suggest that animals are legal persons who have rights of one sort or another. The Indian Supreme Court seems to have beaten the Americans to it. Of course animals have a right to habeas corpus. About 7 hostile arguments are, however, brought against this, but these tend to be mostly dogmatic assertions without supporting evidence. There have been great advances since 1970. Public opinion in favour of animal rights is now huge and growing, and scientific evidence that thousands of species can suffer is also growing. It's clearly time for change. Why is injustice wrong? Because it causes pain. Why is lack of freedom wrong? Because it causes pain. Why is inequality wrong? Because it causes pain. Why is torture wrong? Because it causes pain. Why is boredom wrong? Because it causes pain. And so on, and so on. It's always the same bottom line. It always boils down to pain. Pain, of course, defined broadly, as many other psychologists do. Painism. The term Painism I coined in 1990 to name my own personal moral theory, which I had been formulating since I was at school in the 1950s. Much later, in the 1960s and 70s, I read Jeremy Bentham and discovered that we were saying similar things. One great difference between Bentham's utilitarianism and my Painism is, however, my objection to the adding up of the pains and pleasures of separate individuals, called aggregation, to produce grand totals. Pain has to be felt, I believe, before it's really pain. Yet no one actually feels such grand totals. Yet the feeling part of it seems all important. Also, I dislike the way in which lots of little pains or pleasures can be added together in utilitarianism and used to justify much larger quantities in a sufferer. For instance, the considerable pain of a gang rape victim can be excused or justified if the pleasures of the many rapists are added together, and if this total of pleasures is said to outweigh the victim's pain. Clearly this is unacceptable. So in Painism I say it is invalid to add up pains and pleasures across individuals. At this point I part company with my two old friends Jeremy Bentham and Peter Singer. Yet I think we would all agree that it is pains and pleasures that should form the basis for legal rights. Indeed, I see such a secular theory as the basis for a large amount of law in the future. The central problem is how to avoid the aggregated pleasures of many being used to justify the exploitation or abuse of the individual or few. In particular, we want to avoid the aggregation of the trivial conveniences of the many being used to justify the severe or extreme sufferings of the few. Painism promotes the interests and rights of the individual. Each individual is a universe of experience unto himself or herself. Painism respects this. Anyway, we have over the last 50 years put all animals into politics and into ethics. Now we need to put all conscious creatures into law also, even at the United Nations. All conscious individuals should be citizens of the state, regardless of their race, sex, or species. I should have undone this bit of wire. I'm sorry, I've got to do it. It's beginning to annoy me, having to tear the pages off. I'm awfully sorry. I just forgot to do it.
It's more dramatic.
You think it? Oh, if it's more dramatic, I'll carry on doing it. It's just a very annoying thing. I'm awfully sorry.
It's the corn button.
Probably. Human and animal experience can be divided into two huge realms of pain and pleasure. It seems that all our thoughts and feelings can be divided into one or other category, the painful or the pleasant, the negative or the positive. How does this have relevance for the law? The desired position of animals under the law seems to me to be almost the same as that of children. Bringing Bentham up to date, at last the implications of Charles Darwin are being faced up to. Animals are all related morally as well as genetically. I think we're all moving towards a world society guided by secular moral principles. Jeremy Bentham's utilitarianism is a strong candidate, being based upon common sense and compassion. Science has also provided increasing evidence. But some of Bentham's basic assumptions have not been adequately examined. Maybe we can improve on Bentham. Bentham said that everyone seeks their own happiness and that it therefore somehow follows from this that everyone is also concerned for everyone else's happiness. Clearly, alas, this does not actually follow. Nevertheless, I'm sure that there are such things as natural empathy and compassion. Bentham also claimed that pleasures and pains, benefits and harms can cancel each other out. Within the same individual, this may be true, but I maintain it is not true across individuals. Adding up the pains of individual A and B does not produce a meaningful total. 3. Experience also suggests that within the same person, pains can outweigh pleasures more than vice versa. So given the choice of avoiding an hour's torture or having, say, 2 hours of extreme pleasure, Most people choose to avoid the torture. In this sense, pain seems to be more powerful than pleasure. Even little pains can disrupt big pleasures. I'm not talking about a moral equation, but an actual psychological effect. We should bear in mind that it's quite natural for each individual to seek their own happiness by gaining pleasures and avoiding pains. This is a central issue, it seems to me, for psychology, but not for morality. And the great confusion that we've all endured of looking at the classical philosophers who were obsessed really not about a morality for others, the way which we treat others, but a way of gaining happiness for ourselves. Morality is surely about how we ought to push ourselves, often against our natural impulses, to act to increase the happiness of others. This is a big point. I'm saying that I think that morality is only about how we treat others. When we talk of pains, we're including all negative feelings. For example, injustice, poverty, boredom, fear, inequality, disease, painful thoughts, lack of liberty, or lack of democracy. We have a duty to bring happiness to all other painient beings as much as we reasonably can. Remember, in my theory of painism, I define the word pain to include all negative feelings. We're including all conscious beings in our morality, such as animals, conscious robots, aliens, or computers. Rules for any conscious individuals who are not actually painient, if there are any, will have to be slightly different. Painism also accepts that the reductions or terminations of pains are equivalent to pleasures. Happiness consists largely of pleasures and the absence of pains. When measuring pains and pleasures, we're dealing with both the intensity and the duration of such pains and pleasures. Of course, there remain problems of measurement, but the Home Office has been making progress. I understand that the Home Office now sometimes takes the painist line by not aggregating benefits across individuals when calculating cost benefits under the Animals Scientific Procedures Act of 1986, for example. There are many verbal confusions currently, but to base ethics and law on pain and the avoidance of pain is, I think, a very good thing. It is clear and straightforward. It is strong. We all know pain and we all hate it. The new Animal Welfare Sentience Act of 2022 will require clarity. So this is a good time to be considering such matters. We will have to be careful that the use of the word sentience is not just restricted to non-human animals. We don't want sentience to become some sort of a second-rate form of consciousness that is experienced only by non-humans. This would be yet another form of speciesism. It will, of course, be up to lawyers to interpret the new act and to use it, hopefully for the animal's benefit. Psychologists and other scientists will be on hand, hopefully, to keep them up to date with the science. The science of animal welfare is now quite formidable. I'm proud to say that we in the RSPCA invested over £1 million to develop this science throughout the 1970s and 1980s. So the RSPCA played a major part in developing this new field of animal welfare science internationally. When I joined the RSPCA Council in 1971, no science of animal welfare really existed, or very little, and the RSPCA itself had no written animal welfare policies. So in 1975, I persuaded the RSPCA to let Bill Jordan, our Deputy Chief Veterinary Officer, and myself to write its first scientifically based animal welfare policies. In doing this, we emphasized the importance of mental and emotional suffering and reiterated the role of pleasures as well as pains, for example, the need for genuine environmental enrichment and the measuring of the preferences of animals. which is an extremely useful tool and way of looking at what animals want. Animals cannot verbally tell you what they want, but they can vote with their feet. Ultimately, surely, our aim is to ensure the happiness of all animals everywhere. Because pains can so effectively disrupt happiness, we often attack pains before we go on to promote independent pleasures. I welcome any new proposals, for example, the recent so-called 5 domains approach of nutrition, environment, health, behaviour and mental state that seems to have been suggested in New Zealand. It's good to emphasise the positives and the mental state, which is what the 5 domains approach does. When it comes to ethics, it is, as far as I'm concerned, all about our mental states. Pleasure and pain, positive and negative feelings, happy and unhappy, what animals like and dislike. The great pleasure and pain dichotomy seems to permeate almost everywhere. Painism and aggregation. You can begin by seeing my theory of painism as almost the same as Jeremy Bentham's utilitarianism. Actually, I'd formulated my ideas in my teens, and as an undergraduate experimental psychologist here at Cambridge, before I had read Bentham, so I felt very pleased when I finally read Bentham in the early 1960s. We seemed to agree on most things. He died in 1832, as you know, but is now on display in his box at University College London. I hope you've all visited him. Because, of course, his legacy was very much of relevance to the development of law. However, I believe that pains and pleasures cannot be aggregated, as they're separately experienced by separate people. No one person feels these great totals of pain and pleasure, and surely pain has to be felt in order to be called pain. Besides, one does not aggregate or add up other feelings like loves or surprises or angers across individuals. One would be considered crazy to do so. So why can one be allowed to do it with pains and pleasures? If I said the 50 people in group A are feeling a total of 10 units of love, and 5 people in group B are feeling a total of 20 units of love, therefore B is better than A, my audience would think I was mad, probably correctly. I remain convinced that we cannot legitimately add up the pains and pleasures of many separate individuals and produce a result that means anything. This sort of argument justifies any wrongdoing at all, provided you have enough malefactors who really enjoy doing it. Is this democracy, by the way? Does the mere convenience of many justify the agony of the few? No, the badness of a situation probably measured more accurately by the intensity of pain of the maximum sufferer. If you want to have a shorthand to describe how bad a situation is, you shouldn't try and add up the pains of each individual there affected by it. You should actually look at the maximum sufferers and see how much they're suffering. That's your measure. In my opinion, we cannot aggregate pains or pleasures across individuals at all. Furthermore, I believe that pain is not pain unless it is felt. Of course, I use the word pain as a psychologist tends to do, to describe any sort of negative experience, including negative emotions like fear, horror, guilt, and boredom, and negative cognitions like difficult mathematics, unpleasant ideas, and so on. As I've said, one of the important similarities between Bentham's utilitarianism and my painism is that he uses pain to indicate what is wrong, just as I do. Both of us use the concept of pain as one of our basics. But I go a bit further in pointing out that experiments show that even small pains can sometimes disrupt or outweigh great pleasures. Stopping others' pains, therefore, seems to be more urgent than increasing their pleasures. There's nothing wrong in increasing the pleasures of others. Indeed, it's a good thing, but it's better to try to reduce their pains first, and then, if that is partially or fully achieved, move on to giving pleasures. Of course, both can sometimes be achieved at the same time, and that is even better. Remember that I include all negative experiences within the term pain. Of course, all cephalopod mollusks and decapod crustacea, for example lobsters and octopuses, have recently been recognized in law as being capable of pain. They are now considered to be animals under the new Animal Welfare Sentience Act of 2022. Speciesism. Well, the other word in my title is speciesism, which I coined in 1970. It was meant to bring out the parallels between all of our irrational and outrageous prejudices against each other. Speciesism is like racism or sexism or ageism or classism. It's an outrageous prejudice based upon morally irrelevant physical differences. What matters is that all animals can suffer. Why should membership of another species allow us to torture them or abuse them? What has species got to do with permitting cruelty? The answer is nothing, no more than sex or race. X amount of pain experienced by a dog or a guinea pig is as important morally as X amount of pain felt by a human, or X amount felt by a robot or an alien. In a sense, it is the pain itself that matters morally, not its vehicles. Why should a species difference, or a race difference, or a sex difference allow me to be cruel? It doesn't. Charles Darwin. We still haven't fully accepted the implications of Charles Darwin that all species evolve from a common ancestry and experience pain and pleasure. Darwin himself was tormented by cruelty to humans and animals alike. However, afraid of upsetting other people, he often kept quiet about his theories. Fearing upsetting his religious wife, Darwin delayed publication of his theory of evolution, and afraid perhaps of upsetting his hard-headed and hard-hearted scientific friends, such as Thomas Huxley, he tried not to criticize the cruelty of vivisection. It's likely that he suffered from a number of psychosomatic illnesses due to the awful tensions which he consequently experienced. Darwin regarded unnecessarily painful experiments without anaesthetic, for example, as deserving, quotes, detestation and abhorrence. Darwinism and the theories that descend from Darwin today provide some of the great foundations of modern science. They demand a complete further revolution in our legal and moral positionings of other species. The great separation of the human species from all other living things is, especially since Charles Darwin, completely out of date. It is sheer arrogance and speciesism, as stupid as racism or sexism. Pain is the proper basis for morality and law, I believe, and the fact that all animals, as far as is known, suffer pain and distress in similar ways should now bring all of us under the same or very similar protection of the law. Animal Welfare Sentience Act 2022. So it's fitting that earlier this year, in the Animal Welfare Sentience Act of May 2022, the term animal is reinterpreted to include any cephalopod mollusk and any decapod crustacean. For the first time, non-vertebrates such as octopuses, crayfish, prawns, crabs and lobsters are being included. This is wonderful. Yet we are still boiling them to death in this country as I speak. We need to move on from there to introduce the basic principles of panience into world law, for example, into a United Nations Convention. Lawyers. I warmly welcome the growing involvement of British lawyers into this field. You will, I hope, find ways in which non-human animals can be given more secure and protected positions in law. In many ways, as I see it, in my naive, non-lawyerly way, non-human animals have, or ought to have, the same position as human children, the full protection of the law. Then we need to apply the findings of science in a rational way. Above all, there is now a huge amount of scientific evidence that animals can and do suffer pain and distress. Yet they do not, for example, have the legal right to a name, nor a nationality, nor a right to receive care, nor basic social services, health care, shelter, nor nutrition. Wild animals are given very little statutory help from the state. No one has a duty in law to rescue wild creatures from starvation or plague or natural disaster. They are the poorest of the poor, yet they can suffer very similarly to ourselves. All wild animals are very hard done by. Voles, rabbits, foxes, deer, birds, fish, elephants, tigers, bears, snakes, insects, cephalopods, crustacea are mostly left to suffer and die alone. Our wildlife is a hard life indeed. To make matters worse, the strongest animal of all, Homo so-called sapiens, hunts, traps, shoots, poisons, and chases wildlife merely for entertainment. Pity the poor wild animals in this world. When some humans see the wild ones struggling their best for survival, they just put the boot in. They add a millionfold to their sufferings, peppering them with shot, or trapping them in leg-hole traps, or chasing them for fun. Is there anything more wicked or despicable that a man or a woman can do? To pick upon the weakest and most disadvantaged and to shoot at them, spear them, chase them, or kill them at close range for stuffed trophies, torturing the weakest just for fun. That's what hundreds of British so-called men, along with Americans and Russians and other pathetic specimens of manhood, do in their holidays. They chase, wound, and kill terrified and disadvantaged non-humans just for fun. In some parts of the world, farmers do much the same to increase their profits. Farm animals suffer in millions of cages around the world. So do laboratory animals and animals in circuses or in human homes. Animal abuse is far more prevalent than child abuse. Lord Erskine and Richard Martin. Of course, there have been good lawyers involved in the past, none better than various judges of the Coleridge family and the great Lord Erskine himself. Robert Erskine became Lord Chancellor and in 1809 tried to introduce legislation to protect animals from vicious exploitation. He argued against the immunity that servants claimed when obeying their master's orders, and the claim that as they owned animals, men could do what they wanted with them because the animals were their property. Later he joined forces with another Cambridge-educated lawyer, Richard Martin MP, in passing the first parliamentary legislation anywhere in the world to protect animals from cruelty. That was 1822, exactly 200 years ago this year. So yes, lawyers can indeed feel proud. We're celebrating Richard Martin and Robert Erskine today. Both were Cambridge lawyers. I repeat, 200 years ago they together passed the first parliamentary law anywhere in the world to protect animals from cruelty. Because the quality of panience is not always easy for others to determine, it should be assumed. The benefit of the doubt should be given to the animals. That's why, in practice, any being that may be capable of consciousness should be given rights. History. Can I add a few words here as a historian? It's strange that the worldwide revolution in the consideration of animal rights that took place from about 1965 onwards was led by activists in Britain. 2, that some of those activists were professional philosophers, but 3, that so few were lawyers. Both politicians and public opinion led world opinion in Britain, but there were few British lawyers involved in the 1970s. Why was this? A well-known lawyer has recently suggested it was due to some British lawyers being very fond of fox hunting. They mistakenly may have believed that fox hunting was a badge of aristocracy or career success. Yet the philosophical and political movement flourished in Britain and was extended via international academia and by journalists and politicians. I'd set up Eurogroup in 1980 in Brussels, and it and Compassion in World Farming, together with the RSPCA in the UK, were largely responsible for the 56 reforms in animal welfare law that took place in Europe between the years 1970 and 2010. That's the research done by David Bowles of the RSPCA. For those interested in history, the Oxford Group was formed in about 1970 when Bridget Brophy introduced me to Stanley and Ros Godlovich, graduate philosophers at Oxford University. Bridget and I actually had just been on the world's first ever televised discussion of animal rights, Scottish television, November the 29th, 1969. And I can strongly recommend Robert Garner and Yewande Okule's excellent The Oxford Group and the Emergence of Animal Rights, published last year by Oxford University Press. It's a very academically well-written book. Professor Robert Garner's at Leicester University. Indeed, I suspect it was the open pursuit of blood sports that provoked Britain to lead the new animal rights revolution of the 1960s and 1970s. How do we know there were so few British lawyers involved in the modern revolution? Well, for example, I co-initiated with the Reverend Andrew Lindsay the world's apparently first ever animal rights conference at Trinity College here in Cambridge in the summer of 1977, and I wrote its declaration against speciesism, which was signed by about 150 people, only one of whom was, to my knowledge, a lawyer. That was the late Mary Rose Barrington. Among the 28 speakers at that Trinity conference in 1977, 6 or 7 were professional philosophers and 6 were scientists, but none were lawyers. We missed you. It's so good that British lawyers are now so active. Animal reformers have some powerful enemies, so you're certainly needed to protect campaigners. I was lucky that I had Sir David Napley to help me when I was threatened. I welcome the advent of so many outstanding British lawyers in this field over the last 10 years, notably our host today. I was among those who pressed for a new official committee or commission which has helped to produce the recent Animal Welfare Sentience Act of 2022. As you know, this recognises animal sentience in law perhaps for the first time. It relates to the effects of government policy on the welfare of animals as sentient beings. It sets up a committee which has powers to comment upon government policy to which the Secretary of State must reply. All this is in line actually with our suggestion for an Animal Protection Commission, which together with a lawyer, Katja Lester, I first put to the government in 1977. Indeed, Prime Minister Callaghan wrote to me promising that he would set up a council to do this in 1979, but unfortunately he wasn't re-elected. So we finally got there about 43 years late. We need legal minds working with philosophers, psychologists and other scientists to tidy up the meanings of the words that are being used as far as possible. The new Act, I think, will need this. Currently, 2 government departments deal with cruelty to animals in the United Kingdom, DEFRA and the Home Office. Officials at these 2 departments have become some of the most experienced, I believe, in the world in estimating the intensity of suffering that will be experienced by animals in experiments and in various other conditions. Secondly, in applying Painist judgments when judging cost-benefit analyses. For example, not attempting to judge the great suffering of the few by aggregating the little benefits of the many. The principle here is that adding together of pains and pleasures, costs and benefits across individuals is considered to be invalid. If modern ethics continues to be based upon such principles, I can see modern laws protecting not only non-human but also human animals in similar ways. I think all protective and anti-abuse legislation for human animals as well should be based upon such Painist rules. It is protection from pain that matters. The Home Office administers the Animal Scientific Procedures Act of 1986, and they've become quite expert at what was said in 1980 to be impossible, the estimation in advance of intensities of suffering. As regards animal welfare impact assessments, they have also sometimes tended to follow my painist line in not aggregating pains and pleasures across individuals when estimating cost-benefit analyses. So I welcome the growing interest in animal rights shown by members of the British legal profession. After all, I believe it is the duty of states to protect all painient things within their borders. All painients are citizens. Only perhaps 1% of things in the universe may be conscious. The important cosmic division now appears to be not between human and non-human, but between conscious and not conscious. We conscious and painient things we all need to hang together. Painients of the world, unite. The recent claims that a chat box was asking not to be switched off have received some attention. We simply don't know whether it was conscious. We can't accurately ascertain such things. How can we be sure? Maybe gunpowder is conscious. Well, if you hit it, it certainly may react. But reactions are not in themselves indications of consciousness. Decisions do not have to be conscious. Anyway, sleepwalkers have been said to commit murders while unconscious. Certain types of brain disordered patients too. Consciousness sometimes seems amazingly fragile. Have you never driven a mile or two without apparently having been conscious of the road? I imagine that these matters could be of considerable interest to criminal lawyers. I've spent an hour, for example, walking and talking with someone who afterwards said they'd been entirely unconscious all the time. Quite automatically, he could avoid the traffic in the centre of Oxford while he ignored my questions. Was I literally walking with a zombie? His problem, actually, was temporal lobe epilepsy. One day we will begin to understand how the brain creates consciousness. Is it to be understood through quantum mechanics, the explanation of the very small? When I once said I thought that subatomic particles showed evidence of free will, an old man sitting next to me, who turned out to be Freeman Dyson, the great physicist, agreed enthusiastically. Perhaps consciousness is a quantum thing. Perhaps it's rather like observation itself, something that is alleged to affect the behavior of subatomic particles. This is all speculative. But for lawyers, it may help to say that what I'm proposing is that moral rights should be based on the subjective mysteries of pain and pleasure, and that legal rights should be based upon moral rights. Pains and pleasures are fundamental throughout the animal kingdom. The human species, on average, is in some senses cleverer than other species, but otherwise it is not a special case. Lawyers can be of immense assistance here. Laws should be applied throughout the animal kingdom and throughout the realm of consciousness. Protective laws are for all painient creatures. Lawyers are now needed to work out how the world of law can be extended to all painient things. What needs to be done? I noticed that David Thomas, who is here today, has recently criticised the predicament of laboratory animals. He feels the elementary 3 R's, the reduction, replacement and refinement of procedures, for example, needs to be more formally put into law, along with the harm-benefit test. As one of the drafters of that original Animal Scientific Procedures Act of 1986, in which these matters arise, I warmly concur. The way the Act is enforced certainly needs attention. Scientific benefit needs to be clarified. Maybe the whole idea of a harm-benefit test needs to be scrapped. Prevailing public attitudes have greatly changed over the last 30 years, and the science has expanded. Professor Donald Broom, who, thank goodness, is also here, and is, I have to say, really the pioneer here at Cambridge of introducing a much more sophisticated attitudes towards non-human animals generally. Donald has suggested a number of legal improvements of the current position which could produce huge reductions in sufferings. For example, the introduction of penalties for the gratuitous killing of animals on the road, the unnecessary killing of insects, allowing cats to torture their prey, catching non-target animals in traps, for example in trawling and in bycatches generally, cruel pest control, for example glue traps and pesticides. We've just got the glue traps. Careless habitat destructions. 7, neglecting wildlife welfare generally. Professor Mike Radford agrees by suggesting that legal traps should be taken to expand our obligations to wildlife generally. I very much agree. Mike Radford and Paula Sparks have been outstanding. Many reforms are currently passing through Parliament in the Kept Animals Bill. The hugely important ban on live exports, for example, restrictions on primates as pets, measures against puppy smuggling. There has been a ban on glue traps, the introduction of fixed penalty notices for animal offences, and an increase of sentences in Britain to a maximum of 5 years, at least in England. The Johnson government will go down paradoxically in history as a step forward for animal rights. I'm grateful for this. I hope Labour will be able to keep up. There is still so much to do. Animal welfare science, as Dr. Jonathan Birch points out, the sophistication of an animal is not necessary for its opinions. I would guess with confidence that cognition itself may not be necessary for suffering to occur. Shakespeare speaks of the suffering of a simple little beetle as being as great as when a giant dies. In this case, surely, size does not matter. Many physically little animals have so far been overlooked. My conclusions. More and more humans are understanding that conscious beings capable of suffering are altogether in a special category. In the 1970s, Douglas Lord Houghton and I went around Europe saying it's time to put animals into politics. Up to a point we succeeded. Also in the 1970s and 1980s, we helped to put animal welfare into science. Now I'm suggesting it's time for the next step. It's time to put animals further under the protection of the law. So thank you all for inviting me to speak here today at your most important conference. Thank you.